At that point, he realizes that Gary's been blowing the whistle to his own bosses over at the IRS.
Wow.
And you have the sweetheart plea deal here. The initial thing that they offered required no guilty plea whatsoever. Even sweeter than the sweetheart deal everybody saw.
Yeah, wild.
If we're not allowed to intervene, and there is some judicial finding against them in that case, we would of course argue, well, it's not fair because we didn't have a voice in the process, and they got all these facts wrong, and they got this law wrong, et cetera, et cetera.
Here is what the complaint says. Of course, we're talking about Gary Shapley. He's a citizen of Maryland. We've got Ziegler of Georgia, and he's a lifelong Democrat, which was always an interesting feature of the entire development on this. And Lowell is a citizen of Washington, D.C., handles high-profile cases, and he made his defamation that was carried out in Washington, D.C.
After Gary and Joe testified publicly, right, and they were people asked them about their party affiliation. Gary said, well, I was a Republican, but he's just very middle of the road, nonpartisan. He leaves the hearing, and his mom calls him, all the rest of his family are Democrats. You're registered as a Republican?
That's
funny. That was a big revelation to her coming out of that hearing.
There was nothing political about what these guys did, right? I mean, it was about the work. It was about they had none of those motivations. And their instructions to us when they came to us, was we offer the same information to both sides, be fair to both sides. Once you go out there on something like this, though, then you sort of attract, you don't have control over the friends and enemies you attract when you get a political hot button issue.
Yeah, this polarizes everybody. Even it sounds like the family are going, what the heck? Revelations across the board. So that's interesting. And I know the politics, their political positions, it did come up, but it never struck me as political. I mean, these guys were both, I think, in their positions for decades, right? Or at least Shapley was like decades.
Yeah, both of them have been for quite some time. The team that they're on is like the crack international tax investigation team for the IRS. That's why they had this case, right?
Yeah.
So Gary was Joe's supervisor. And so, a number of like very high profile cases. Gary worked on like the Credit Suisse, all this tax recoveries from Swiss banks, right? And so these guys are extremely experienced. And that's why this one stuck out of them so much, because they had never had a case treated with such kid gloves before.
Yeah, they seemed like the A players, right? Some of the best in the government. And so for them to come out and stand behind it, and the way they testified, they were so articulate. They knew this stuff like the back of the hand. They just demonstrated competence. So
Gary's been responsible. He's overseen cases and worked on cases that have brought in billions of dollars from people who were cheating on their taxes and trying to hide the money overseas. So, I mean, he was a rock star before all this happened.
Yeah, and then he crosses the wrong narrative, and then suddenly he's excommunicado. But I wanted to ask also, while it's on my mind, about the process a little bit that they go through before it reaches this stage. Before these guys actually contact you, or before they reach out, before it hits Congress, I guess. They're working internally with their supervisors and stuff. I mean, they're trying to solve this stuff. How does that work?
So Gary, and it's actually pretty central to what happened, but when all throughout the case, so you've got the IRS, they're working with the U.S. Attorney's Office for the District of Delaware, and then the DOJ Tax Division. So Gary is making protected disclosures up his chain of command throughout this. He's saying, these guys are not treating it the same way. They seem to be obstructing some of these inquiries. So he's putting that in reports all throughout. His supervisors were like, this is a super hot potato. We don't want anything to do with it. Like normally you wouldn't have someone at Gary's position communicating with the U.S. Attorney for the District of Delaware. They said, yeah, you go be the one to go to those meetings. You go be the liaison. They don't want their hands.
Yeah, I remember that.
But when things started to unravel, when David Weiss, the U.S. Attorney for Delaware, first in a meeting said, well, even though we had recommendations to charge in both D.C. and in California, we went to the D.C. U.S. Attorney, and he's really not interested. And Gary had been paying close attention.
Biden appointed D.C.
Right.
Biden appointed D.C. U.S. Attorney. But Attorney General Merrick Garland had been out there in front of Congress saying, no, this is completely non-political, and no Biden appointees weren't going to have hands on it. Weiss has got all the authority that he needs. And so for Gary, that was like a huge switch to say, you're telling me that if you don't have the control over bringing these, that contradicts what the Attorney General's been saying publicly.
Yeah.
And Congress had been breathing down Garland's neck about the case because of the obvious potential conflicts of interest, saying, how are you going to ensure that there aren't those conflicts? So in that meeting, Gary raised these issues. So he had been going internal, but that was the first time his concerns kind of jumped over and that Weiss became aware of them. And that's when the kind of bigger retaliation started, because Weiss then said, oh, wait a minute. Okay, produce all of your emails. We want the discovery on this case. He goes through and sees Gary's Shapley's communications with his chain of command. And, from there on out, Weiss.
At that point, he realizes that Gary's been blowing the whistle to his own bosses over at the IRS.
Wow.
And then guess what? He stops getting invited to the meetings, the weekly meetings that they were having on this case for years, right? And all of a sudden, he's the supervisor of the case agent. And he's not invited anymore. They go silent. And then, the machinations.
The case agent wasn't either, just to be clear. It wasn't just Gary, right? The whole entire team, which now we know because
eventually.
Investigation. Well, but even
eventually they took the whole team
said no Gary, no Joe, none of the team. So they were cut out entirely from the outset, even before they knew they had been reassigned.
So at that point, that's when Gary, to answer your earlier question, that's when Gary starts thinking, okay, wait a minute, I got to get a lawyer. I got to figure out who I can tell, how I can tell them. And so that process sort of began pretty much immediately after that meeting in October. And then so, by January of the following year, he's found a lawyer. That lawyer eventually finds us to get us to help. He goes and he makes disclosures internally to the Justice Department Inspector General, to the Treasury Inspector General for Tax Administration, something called TIGTA, which is basically the IRS's Inspector General. So he made those disclosures privately. And then we made the decision to reach out to Congress and say, hey, Congress, can you help us facilitate coming to you with this information? But we got a problem. Like, we need to have, in order for him to tell even his lawyers, he had to have some kind of special authorization from the committees, and they have the authority to do that. And so they eventually did that. Both the Democrat in the Senate and the Republican chair in the House both gave letters that said, look, we want to hear what you have to say, because he couldn't say what it was. He just said, I have something important that I think you want to hear, but I can't tell my lawyers, and I can't get in, I need their advice to come and testify. Will you authorize me to tell my lawyers? And so that's what he did.
And we should clarify
what the chairman did.
Like I said earlier, the law allows whistleblowers to go to those committees. It doesn't say anything about lawyers. There's a good argument to make that if you're seeking legal counsel, you're seeking legal advice, that you could tell your lawyers in the context of utilizing whistleblower statute. We went above and beyond in going to Congress and saying, it's ambiguous, so we're not going to test it. Will you just clear us? We didn't necessarily have to do that, right? But we did. That's how careful we wanted to be to make sure that there was no, spillage of this taxpayer privacy information. And so we got that authorization to go.
Right. And then sort of briefly go through the rest of the chronology then. So what happens at that point is they get the authorization. Then he's able to, he gets his lawyer's help with legally to prepare the disclosure. They go in, they give a proffer to the committees. They say, here's what he's going to testify to. Do you want to bring him in for an interview? And then they do that all behind closed doors. It's all still protected by the tax statutes. And then the committee decided later that summer to have a vote and say, hey, the public needs to see this, or the rest of Congress needs to see this. The Judiciary Committee needs to see this, right? Because we couldn't even go to the Judiciary Committee in Congress. You have to go, the statute says you have to go to that one committee, the tax committee.
Wow.
So that's why they voted to refer it to the rest of the House, which makes it public, which intentionally and purposely, that's the same thing they did with Trump's tax returns, right? And so once they did that, then Gary and Joe were, at that point, they're just like anybody else. They have the right to talk about it. They have whistleblower protections to talk about it. As long as they're not revealing anything new that wasn't already revealed in the House, then there's nothing wrong with that. And anybody would know, that's how it works. Anybody who knows what happens with the Trump tax returns knows that, right? The members who saw the Trump's tax returns before they released them, even the members of Congress, they couldn't talk about them legally until Congress voted to release them. Then once Congress voted to release them, all those members were out there talking about it. Gary and Joe are in the exact same position.
Wow. Okay. So that is a lot. And I didn't realize the process was really that extensive. So there was a ton of stuff happening before we ever saw those guys testifying in front of Congress. It was happening for a very, very long time.
Months.
Yeah. Which there's all sorts of repercussions, consequences from that. Now, from where I'm sitting, it's going to suppress anybody's willingness to be a whistleblower, right? To have to go through that, the ringer and all that. But these guys stayed within the system as best they could for years. And what's also interesting about this is that Shapley, right, is like an expert in this field. So he knows what he can talk about and what he can't talk about. And so he's trying to color in the lines until the retaliation starts. Then he goes through this entire process. And I'm imagining at every single step of the way, at every one of those, it's another like whack-a-mole. It's another opportunity for the bureaucracy to just knock these guys down, knock you guys out, to stop all this stuff from ever reaching the public.
Yeah, that's essentially right. It's important to understand, although it was a big step for him to go to Congress, again, that is protected. And so I think, on the one hand, we sort of laud people who are like, well, you worked within the system, right? There's kind of an ethos of like, oh, you're a company guy, good job. But certainly as former congressional staffers, Jason and I would say, look, it's important to understand that it's okay to go to Congress. There are protections for that for a reason. That's part of the constitutional separation of powers and the checks and balances there. And so that's not going outside of the system or something else. Congress set up the system. Congress is who established these various departments, right? Congress
They're also part of the system.
Protections. Yeah, exactly.
Yeah, amazing. Well, we're glad that you guys are doing the work that you're doing, because it's a big maze of confusion, I'm sure, for people who are just working their job, in the government. They've been doing this for a long time. They see something problematic. They're trying to figure out, what do I do about it? And to have you guys help them navigate through that is a real service. So we're grateful for that. So a little bit of background on Abbe Lowell, right? He's been around for a long time. He's been representing the Hunter family attorney. He's kind of known, I think, as an aggressive, very litigious, very colorful attorney, right? We've read a lot of his stuff on the show here, but he's also maybe colors outside the lines a bit too, right? He just got scolded in California on another case, and we were talking about that yesterday. Can you refresh our memory on that one, right? He got scolded for something?
Judge Scarzy? Yeah, well, Judge Scarzy in the criminal tax case in California, the prosecution of Hunter Biden threatened to hold, he issued what's called a show cause order.
That's right.
That basically said, explain to me why I shouldn't sanction you, because, Judge Scarzy thought some things that were in his pleading, were false, and that he wanted to hear an argument as to why he shouldn't be sanctioned, because it sure looks like you know better than what you wrote here. He ultimately didn't sanction him, to be clear. The lawyers came back with, an explanation. Oh, I'm sorry, I didn't mean to say it that way. He took that for what it's worth and didn't sanction him. But Judge Scarzy is known to be very, very strict with lawyers and the truth.
Yeah, good. They should be truthful in their filings to the court. And the reason I brought that up is because it feels like there's a pattern here of Abbe Lowell, who's constantly manipulating the truth, or in this case, lying about the truth, defaming people, libeling people. And even judges are noticing it, saying, hey, you should be a little tighter with that language, color in the lines here. So here's the background. You say on September 14th, Lowell sent a letter, this is what you described earlier, to several congressional committees, which included many of the prior communications that Biden's lawyers had sent to the government. So these are other attorneys, I guess, from Hunter?
Chris Clark was for a lot of this, some of the initial letters, although Abbe Lowell also sent some of the earlier ones.
That's right. Yeah, Chris Clark. And he was there for that original plea deal that went derailed, right?
Yes.
And that was a scene. I don't think I'll ever forget reading that transcript here on how badly that went, because I think that Hunter, if he would have just taken that plea deal, he could have avoided a lot of this additional consequence, and the DOJ would have continued to cover up for him. But any thoughts on that? Any reaction to that?
I think that's exactly right. One thing that a lot of people probably don't know is, and it's almost like a 3-act play, right? A lot of people bring up the third act here and say, see, he's being punished. And, you have to go back to the earlier acts. But I think one of the kind of second act of it was that, of course, the first act is the government agreed with the IRS that Hunter Biden should be charged and all these things. Again, as we described before, he goes to these different U.S. attorneys' offices, he's rejected. The second act then is it's laying entirely quiet. So at the time Gary comes forward, there had not been any activity on the case for several months. Before, they're having weekly calls, right? There's all this activity. Suddenly it's all quiet. And so when our first letter goes indicating that there's a whistleblower intending to come forward, immediately after that is when the U.S. Attorney's Office in Delaware first reaches out to Chris Clark to offer a plea deal. And you have the sweetheart plea deal here. The initial thing that they offered required no guilty plea whatsoever. It's even sweeter than the sweetheart deal everybody saw.
Yeah, wild.
And then after that is when Weiss said, maybe that's not a great idea. And then they came forward with the one that all the public saw. But I think you're absolutely right. DOJ just want to put a box on that, put a box on the ribbon and get it out.
And the timeline gets a little complicated. And I think people can easily be confused about it. But, what you need to understand is because they gave that closed door testimony, and because, the attorneys went in and gave an attorney proffer to both the House and the Senate, before they even came in to testify, there were lots of people, sort of in the know on the committees on Capitol Hill. And, that it wasn't a secret, certainly wasn't a secret inside the Justice Department or even on Capitol Hill, that these guys were coming forward, that this was a process that was moving forward. It just hadn't broken into the open yet because it couldn't, until the committee took their testimony and voted to release it. So,
but David Weiss knew exactly what was going on. David Weiss had already butted heads.
He knew what was coming,
right? And so he says, I know what this guy has to say. He's been saying it to his supervisors for years.
Yeah. Well, when was that? Because there was the original plea deal, which was basically like a diversion deal, right? Like he was just going to sign something and everything was going to go away, no convictions at all. Then I felt like then there was some disclosure. We learned more about this, and then there was like some pressure maybe from Weiss's office to increase the penalties a little bit and then give him that sweetheart deal that we saw. Is that more or less?
Right. That was right. With us going in for their interviews. So again, those were happening kind of roughly the same time that they're trying to, again, box that up while the whistleblowers are being interviewed, those transcripts are being prepared. And so then the way that it finally breaks out into the open, again, our first letter is sent in mid-April. It's not until June 20th.
It's important to note that our first letter, it doesn't say anything about Hunter Biden. It doesn't say anything about the District of Delaware. It doesn't even say Gary Shapley's name, right? It says, I've got a client. He wants to make some protected disclosures about a big tax case. Will you help us? That's all the first letter says. And yet, Abbe Lowell claimed in his lawsuit on behalf of Hunter to the IRS that was somehow a violation of something, right? It didn't disclose anything about Hunter Biden. It was just like, hey, we have something we want to bring forward. Now, eventually during that process, the committees, and people behind the scenes knew what it was going to be about because, we did a situation, which was all appropriate.
And to that timeline again, so Gary's interviewed on May 26th. So that's almost a full month before it becomes public. It becomes public on June 22nd. So for a whole month, Democrats, Republicans on the Hill know what that testimony is, who are on the tax committee, right? But you could also, without revealing any of the substance there, say, this doesn't look good, guys, to DOJ. And so then it's on June 20th, the DOJ pops up out of nowhere and says, oh, actually, we have a plea deal. Hunter Biden's pled, everything's fine. Chris Clark goes was in an interview and he said, after 5 years, he's asked, it seems really, all they came up with was these 2 misdemeanors. Like, you feel like that was a waste of their time? And boy, he just looks like the cat that caught the canary. He just keeps his face, says, well, after 5 years, this is what we got. This is where we landed. And of course, he couldn't have been happier, right? But 2 days later,
if they had wrapped the testimony came out, it would have been, oh, that's old news.
Wild, man. And that timing was just perfect. And then Hunter rejected the plea, and then, the whole thing started to open up a little bit more. So what a trip that was. These are the actual lies that Abbe Lowell is now sending in letters. So it's paragraph 25 of your complaint. It says, so Abbe Lowell is sending a bunch of letters off. These are the letters you referenced previously, sending these all over the government. Apparently, he sent one that says, yet another federal agent, Joseph Ziegler, illegally leaked information protected by the rules, right? So this is Hunter's lawyer sending letters encouraging the prosecution to agencies that his daddy runs. Saying more of Shapley says, there is no justification or cognizable legal protection for the whistleblower disclosures of confidential grand jury and tax information, and such disclosures are not protected by any exceptions. So his lawyer says that Shapley's unlawful disclosures are quite simply felonies, right? Like, that's aggressive arguing. Charge your clients with a crime. To daddies, these are going to the DOJ. Was he copying you guys on these? Like, did you guys know about this?
We know somebody was giving them to the press because we got questions from the press about it. The New York Times called us right after their testimony came out, right after the House Tax Committee voted to release it. And they said, hey, we understand there's this letter where they're arguing to the Justice Department that your clients, violated the law. What do you have to say about that?
Wild.
So we knew at that time that they were distributing those lies, outside of the normal process directly to the press, or at least somebody was.
Well, and guys, that puts you also in the crosshairs a little bit, right? Because you're the lawyers advising these clients, and they're looking at you guys saying, oh, maybe these guys, right? They're indicting lawyers all over the country for stuff that they were working on. So
and imagine, put yourself in Gary. Right? So you're already, you're suffering consequences at work. You've got other cases that you're working on, other big cases that all of a sudden, they have to have 14 levels of approval now, right? And they're shutting other projects you're working on down just so that, in your next performance appraisal, you're not going to have good metrics, right, to show what a great job you did. They're literally letting tax cheats go because they don't want to give Gary a win, right, as retaliation. They're denying him promotions that he's applying for. So you're going through all of that at work, trying to just keep your head above water and do your job in an environment where everybody's looking at you sideways and cutting you out of stuff. And then you find out, the president's son's lawyer is asking the Justice Department to prosecute me. It's intimidating, and that is, we believe that was the purpose of it, was to intimidate and make sure that nobody else talked.
Yeah, and then you guys discovered all of this when?
So because these letters, references to different letters popped up in a couple of different stories. So in September, the 3 committees investigating Ways and Means, Judiciary, and Oversight sent a letter to Chris Clark and Abbe Lowell and said, we hear that behind the scenes you may be encouraging prosecution of the whistleblowers. We demand that you produce to us all of your communications with the Justice Department. So Abbe Lowell doesn't respond immediately. Then the committees also write to Merrick Garland, also asking for the same information. So Abbe Lowell is kind of boxed in here. So Lowell produces the information to Congress and says, yes, I'm giving all of it to you. And what's more, I'm happy to share it with you because we do think these guys did something wrong. And I'm releasing it to the public. If you just stopped and if he's giving it to Congress, perhaps there's an argument that you can make that it was privileged. That's not a judicial proceeding, but he didn't stop with that. He released it also to the public.
Which shows he wasn't just trying to make his case to the committee, right? And this is what the complaint alleges, right? He wasn't just trying to make his case to the committee. He was intentionally republishing all of these false statements to a wider audience, to the public.
Right. I guess he's hoping for a media smear, or was this something that he was thinking would actually develop into charges? I mean, is he trying to create energy for charges, or do you think this is just a distraction type of a tactic, or what was the intention of this ultimatally? Or did the DOJ bite on this?
No, we have no indication that Gary has been seriously investigated at any point by even administratively.
I think it's important to know that after the plea deal fell apart, right? Concurrent with that, so one of the other kind of things you may remember from the plea hearing is that the day before that, there was this whole scuffle over whether Chris Clark had pretended to be someone from Chairman Smith's legal team, right? And said,
I remember that.
Document down. And so again, there was a show cause order, saying what happened here.
It was a legal assistant or something filed something or something went weird. Yeah.
Yeah. So Clark's team said, well, we weren't representing that we were there with the committee. But basically, Chairman Smith submitted this amicus brief, friend of the court brief, that included the IRS whistleblower transcripts. So Judge Noriega had all of that to consider when she had that plea hearing. And so Chris Clark was there arguing along with Abbe Lowell that it shouldn't even be entered into the record. And so both Judge Noriega said, you haven't pointed to anything specific that shows me that this is a violation of grand jury secrecy laws or anything else. And similarly, an assistant U.S. attorney in the Delaware office also told them directly, we're not aware of any illegal leaks or anything else like this that you're referring referring to. So he had all of that background before then just proceeding to file the lawsuit against the IRS.
Yeah, so you basically had a judge saying your allegations that all these things in the whistleblower's testimony violate grand jury and tax secrecy. No, she swatted away. She said that's not right, and I'm not taking them down. They're still on the court docket. They still are right now.
But so then he's suing the IRS to get compensation and then to also close the deal out, or is he asking the IRS to sanction your clients? Is that still a possibility, or do something?
Well,
I
think that would just be a natural consequence, right? That's what we've argued in our motion to intervene. We said, look, we have a concrete interest. Both the government and Biden have a concrete interest. They're not parties. They shouldn't be able to have a voice in this process. And we said, what do you mean? Like, if there's a judicial finding that they violated the rule, then like their jobs, like they can't continue being criminal tax agents at that point, right? I mean, their careers would be sort of officially over. So they do have skin in the game. They have concrete interest. They have Article 3 standing. They should be able to intervene. So that's what we've argued in the case. So I think that's, the likely, I mean, we would argue, of course, that like, oh, well, the judicial finding is, if we're not allowed to intervene and there is some judicial finding against them in that case, we would, of course, argue, well, it's not fair because we didn't have a voice in the process and they got all these facts wrong and they got this law wrong, et cetera, et cetera.
And where is that one filed?
To your question, that one's in
DC.
DC. To your point, though, he is asking for damages, right? Declaratory relief for Hunter Biden.
And there's a concern that maybe the IRS settles that, right? And actually just comes to some agreement.
Yeah, or just doesn't do or just doesn't really
lays down on that.
It.
Okay, so let's talk about damages. So I referenced this earlier, but the total amount of damages is $10 million apiece, right? So for Shapley and for Ziegler, and I hope they get, and you guys get every penny plus some. But walk us through maybe the personal side for these guys, right? They've been put through the ringer on this. So how are they doing? How are you guys doing? Talk about the journey that everybody's been on, because I know it has been a lot.
So I came to Empower from a position on what's called the Merit Systems Protection Board, which hears these kinds of employee appeals, appointed by President Biden as the Republican on that board. So the whistleblower laws we knew very well. And so right from the outset, I remember Gary looking me in the eye and asking, am I going to be screwed when we do this? Right?
Yeah.
Saying, no, there are whistleblower laws in place that are to protect whistleblowers. There's going to be a lot of public scrutiny on this. We are meticulously following every one of the legal procedures here. So, they might make your life a little miserable, but there should not be kind of big long-term consequences. And I've had to eat my words some because, again, Gary's been passed over for several promotions, and the vindication process is a really slow one. You have to go to the Office of Special Counsel, another agency that I served at previously. You have to file your complaint. They have to go through this investigation. One of the biggest kind of blows to them was being removed from the Hunter Biden tax case altogether. But that's, the law doesn't necessarily, it's not clear whether that would be considered as a personnel action or not, because it's one of several cases that you have, even though, Joe Ziegler is the one that first opened this case for years and years, right? He spent so much time investigating this. Clearly, there was a lot to investigate, as anyone who has seen, the filings in the California case will see, right?
Yeah.
So having gone through all of that, right, to take them off the case was significant. But so it has been very hard for them, and especially to see their name dragged through the mud. So one of the things we haven't talked about is that Mitch Langberg is the defamation attorney. He's a very high-profile defamation attorney. He represented Steve Wynn in a lawsuit against Girls Gone Wild, where a jury awarded $40 million. Judge cut it down to $20 million.
Yeah.
And so again, he's just a crack defamation attorney. But so, it's meant a lot to them that he was willing to take this case. It's really interesting that he has said, not knowing much about it before ever engaging on the facts and talking to us. If you're just someone that kind of consumes the media, all you get is the impression these guys did violate the law. And so going into the facts for him was really an eye-opening experience to say, wow, you guys really tried to do the right thing, and this is where you ended up. So they very much are hopeful that they'll be able to vindicate their name, regardless of the ultimate outcome of the defamation suit, for people to understand, right? Even if they say, well, you didn't violate the law, whatever the ultimate standards are to prove defamation. But, again, if they can explain that to the public and have the public understand, that's a significant development.
On damages, you should also understand that your audience should understand, because they were being accused of a crime, that's what's called per se defamation. If you're accused of a crime or something else that makes it, that's completely incompatible with your profession, right? Which obviously committing a crime would be for a criminal investigator. That's per se defamation. What that means is that you actually don't have to prove exact damages at trial. The damages are presumed. It's presumed that if you're accused of a crime, that's going to be damaging to you, which obviously would be, as I said, for any criminal investigator to be accused of a crime.